Hello everyone, myself Tushar. I am pursuing BA from JCCLC Kolkata, and currently I am a legal intern at LEXIS and Company law firm. So today I am going to discuss about the concept of vicarious liability. So the general rule of thought is that who causes the damages must pay compensation for the damages. But if there is a certain relation in the between the third party and the defendant, then the damages can be paid. Then the court can liable the third party also to pay the damages, as if some essentials are fulfilled. These are the essentials of a vicarious liability. So the first is that there must be a relationship. And second is that at the wrong done in the course of action. So the first is to understand and the concept of vicarious liability, we must have to understand these essentials in depth. So the first essential is that there must be a relationship. So what type of relationship? The relationship which in which the types of relationship in which the concept of vicarious liability applies, like the master servant relationship, partnership, and employer employee, and the and principal agent. So these are some of the relationships in which the concept of vicarious liability applies. But there are some relationships in which the concept of vicarious liability doesn't apply to the third party. So what are those relationships? Those relationships is of independent contractor. So many can say that a independent contractor and master servant relationship are the same, but there are some differences between the independent contractor and master servant relationship. So what are the differences? The first difference is that in the case of the master servant relationship, the master is liable for the damages as made by his servant. But in the case of the independent contractor relationship, the master is not liable. And the secondly, that you have an employee contract with the servant. But in the case of an independent contractor, the independent contractor is in a contract of service. Is that And the third point is that in the case of the master servant, the servant is totally under the control and directions of the master. But in the case of the independent contractor, the contractor is not totally under the control of the master. As you can say the contractor what to do, but how to do it is totally in the free will of the contractor. So he is more and more independent than a servant. So these are the differences between the servant and the independent contractor relationship. Now let us understand a very famous case law in this independent contractor case. So the case law is B Govind Raja Alu versus is MLA A Govind Raja Mudaliar. In this case, there was a mechanic, and there was a person who visits a mechanic and gives his car to the mechanic for repair. Now, while test driving the car, the mechanic hit somebody, and and then the person who was hit by the mechanic filed for damages is in the court. And when the matter went to court, the mechanic said that I have hit the person, and in the course of action of doing this of doing in the course of action of doing his job, so I couldn't be liable for these. Is so they say but the court said that no, as you are an independent contractor, so the so for your actions, hence he cannot be liable. Now the second essential is the wrong must be done in the course of employment. So what is a course of employment? And the basic question would arise in your mind. So we could understand and the course of employment more or briefly by researching some case laws. I am going to cite some famous case laws. Is that as SBI versus Syama Devi. In this case, basically what happens is is that Syama Devi has a friend who is a bank employee, and the bank and her friend says that give me your money and I will deposit it to your bank account in SBI. So Syama Devi gives her money to his friend, and his friends doesn't deposit the money and flee with his money. So after her friend flees with her money, then and she filed a suit against the SBI that she that at that he to held SBI vicariously liable for the actions of his employee. But the court held that as since you gave the employee since you gave the bank employee the money not because he was a bank employee but because he was your friend, so the SBI cannot be vicariously liable and it is not his course of action. And the second and case law, Beard versus London Omnibus. So Beard versus London. So in Beard versus London Omnibus, what happens is that at the conductor of the bus, while the driver was eating, tried to turn the bus to save time for the driver. But while turning the bus, he hit somebody. The person name is Beard. Let's say Beard was hit, and the Beard was hit by the bus. And then Beard approached the court for the damages against the London Omnibus to hold them vicariously liable for the actions of of their employee. But the court held that since the conductor was not hired to drive the bus, and by driving that bus he is not doing his course of action. So the London Omnibus Company cannot be held vicariously liable. And the second case law also relates to London Omnibus. So the case law is Limpus versus London Omnibus. So in this case, basically what happens is that at the driver of London Omnibus was driving the bus, and he met into an accident and in the accident, Limpus, a person, was badly injured. So he claimed for damages as from London Omnibus and to held them vicariously liable for the actions of his employee. But London Omnibus as company said in court that the driver was driving in the bus and racing with other buses, and in our course of employment it is specifically mentioned that it is prohibited to race with other buses, so we are not held vicariously liable as it is not in the course of action. And so the court held that as the driver is hired to drive the bus and it is the course of action and you are held vicariously liable. So thank you guys, that's all in vicarious liability. This is Tushar signing off.